And there's preachers every Sunday, muscadines each fall. I'd like to die in Arkansas if I should die at all.
Welcome to ArkanSense. I'm Houston Hughes, and today I'm going to be talking to you about the 2018 midterm elections. Specifically, this will be the first in a series about Arkansas ballot initiatives, statewide laws that you get to vote on. Ballot initiatives make it to the ballot because of either a petition that gets enough signatures from the citizens, or because they're referred there by the legislature. Issues 1 and 2 are both amendments to the Arkansas Constitution. In Arkansas, if the state government wants to amend the Constitution, the amendment has to get a majority of votes in both state houses and also a majority from we the voting people on a statewide ballot. Amending the state constitution is a purposely difficult process in order to keep the basic rules of our state from constantly changing with whichever party or person is in power. So keep in mind that if issues 1 or 2 are passed, it would be just as tough to ever reverse them. Also, issue 1 was tossed off the ballot as of September 9th. However, it will be challenged in the state Supreme Court and may end up back on the ballot. So it's important to understand it. And with that, let's dive into Arkansas Issue 1, a cap on attorneys' fees and damages awarded in lawsuits. Issue 1 would place a cap on fees paid to attorneys and awards for damages in civil lawsuits. The award cap, set at $500,000 and to be later adjusted for inflation, is for damages that do not have a direct dollar value, like pain or emotional distress or loss of life. The cap also applies to punitive fees, which are added on top of regular payouts as a form of extra punishment. Also, contingency fees, payments made to lawyers only if they win the case, would be capped at 1/3 of the total case winnings. In addition to setting those caps, Issue 1 would also allow the Arkansas state legislature to set the rules for pleading, practice, and procedure of civil cases. Civil lawsuits, sometimes called liability lawsuits, are cases regarding harm done to a person or group of people because of an accident, a breach of contract, or any other personal dispute that's not covered under criminal law. The area you may hear about these most in the media is medical malpractice. While this law would cover all civil lawsuits, it's clear that a lot of the focus of the liability caps is the medical field. This is also reflected in the groups who have endorsed Issue 1. About half of them are healthcare groups. So why would anyone want to limit the amount a lawsuit can pay out? Supporters of Proposition 1 say that fears of frivolous lawsuits stifles small businesses. For example, if a small business is threatened with a lawsuit, even one with no real merit, the business might feel forced to try and settle out of court if they think that bringing the case to trial and losing could mean bankruptcy. A cap on damages might make those businesses more willing to take those cases to trial, and in turn make those frivolous lawsuits crop up less often in the first place. And when it comes to the medical field, people in favor of Issue 1 argue that frivolous and expensive cases raise insurance premiums for doctors and hospitals and force doctors to practice defensive medicine. So what is defensive medicine? Imagine you go to a doctor with a set of really common symptoms. The doctor might feel confident in diagnosing you without the need to run additional testing. Problem is, the doctor also knows that there's a tiny chance it's something more serious. If they miss that and you end up suffering as a result, you might then sue them for having not been thorough enough. Practicing defensive medicine means the doctor might order tests they think are probably unnecessary just to create a lawsuit-proof paper trail. The price for these tests then goes to your insurance and ultimately to you. So supporters say that putting these caps in place would save doctors and patients money and encourage more and better doctors to move to Arkansas. And they'd also say those same principles would apply to a large number of other businesses. So what's the other side to this? When it comes to the medical community, there seems to be no doubt that defensive medicine is an issue, but there's also little evidence to suggest that damage caps do anything to curb it. States that have enacted caps similar to the proposed one have not seen a substantial decrease in medical costs. For example, look at our neighbor, Texas. In 2003, Texas enacted a liability cap using the same arguments you're seeing for Issue 1. But then between 2003 and 2009, even though medical liability insurance companies did face fewer lawsuits, doctors' premiums did not significantly decrease, meaning most of the money saved by enacting the cap was just pocketed by insurance companies. Meanwhile, during that same period, the cost of healthcare in Texas increased twice as much as the national average, and spending for diagnostic testing increased at a rate that far exceeded the national average as well. So doctors definitely weren't practicing less defensive medicine, and people visiting doctors were paying more. Another thing that critics of Issue 1 say is that while this cap might make people less litigious, it could just as easily scare away a case that's frivolous as one that's completely legitimate. Imagine you've got an airtight case that a big Arkansas company did something really terrible, maybe even something that cost the life of a loved one, and in this scenario, you don't have very much money. Because of the cap that Issue 1 places on contingency fees, a lawyer might be less likely to take your case in the first place. If you do manage to hire one, you'll need to pay them and their legal fees for as long as the case goes on. But if the company you're suing is big enough, you can be sure they have the resources to drag out the case as long as possible if they think it might make you give up. All the while you're enduring even more stress during what's already an emotionally trying time. You might look at that maximum amount of compensation available and decide that what you could win is outweighed by what you stand to lose. And before you start thinking this is just another liberal versus conservative, people versus businesses issue, there are actually some conservative groups who've come out against Issue 1 as well. Pro-life groups like the Family Council and Protect Our Families argue that putting a cap on suits involving loss of life is equivalent to setting a maximum value on a human life. If you're the kind of person who believes that an unborn fetus is a human full of infinite potential, it would make a lot of sense that you wouldn't want a cap on what you could sue for if, say, a workplace accident caused someone to have a miscarriage. Some of these groups also worry about folks in nursing homes, arguing that neglect of the elderly could become more likely if there's a limit on the potential financial liability. So now you know the arguments for and against these lawsuit caps, but don't forget that's only one of the two big things that this issue does. As I said earlier, in addition to setting those caps, Issue 1 would also allow the Arkansas State Legislature to set the rules for pleading, practice, and procedure of civil cases. As it stands right now, those rules can only be changed by the judicial branch of the government. The process to do so, just like the one for constitutional amendments, is purposely difficult so they aren't constantly changing. First, there's vetting by legal committees, then the public has time to voice comments or concerns, and then the opinions of the experts and the public are passed on to the state Supreme Court, who ultimately make the final ruling. If Issue 1 were to pass, then the power to make those changes in civil cases would move from the judicial branch to the legislative one. This is a big deal. Most of you are probably already familiar with the term separation of powers, the idea that our government, both on a state and a national level, is divided up into multiple branches, with each branch having strong power over its own domain, but very weak power over the others. This system exists to keep power spread out and make it harder for one person or a group of people to decide everything. So any attempt to move power from one branch to another is worth checking out thoroughly. People who are for Issue 1 would say that this part of the amendment is necessary to protect the rest of it. A bit of history. Before the year 2000, there was some serious overlap and some heated arguments regarding which bits of judicial policy were under control of the legislature and which ones were controlled by the courts. But then, our state passed Amendment 80, which was meant to modernize our state's courts and bring them more in line with how things are done on a federal level. Part of that amendment was clarifying that these rights to set procedure belong to the judiciary. Since then, anytime the legislature has tried to pass rules regarding case law, the Supreme Court has struck them down as unconstitutional, specifically in violation of Amendment 80. So a supporter of Issue 1 would say that this change is being made to make sure the courts don't have the power to strike it down if it passes. They would also say that giving this power to legislators will make the process more responsive to us, the people that elect them. On the other side, people against Issue 1 say that allowing the rules for lawsuits against businesses to be set by legislators who are often lobbied by those same businesses opens up the system to corruption. And you know who has some pretty big pockets for lobbying? Those insurance companies we talked about earlier, who pocketed the difference after a law like this was passed. Another worry that some opponents of Issue 1 raise is the idea that our legislature might turn civil cases into a loser pays system, where if you sue someone and lose, you're responsible for their attorney fees. That might sound great if you assume only frivolous cases lose, but of course that's not always the case. And that kind of system could further prevent poor Arkansans from pursuing legitimate cases in the first place, for fear that if they lost, they would never financially recover. And that's it! Congratulations! You made it through a difficult discussion of tort reform, but now the real question is, how should you vote? Well, if you're the kind of person who believes that frivolous lawsuits are stifling business growth and hurting doctors, and you believe that lawsuit caps and giving legislators more direct control over the rules for handling those lawsuits will make it better, then you want to vote for Issue 1. On the other hand, if you're more worried about poor people with legitimate cases being scared away from pursuing their lawsuits, or if you want to make sure there's not a maximum value set on loss of life or limb, or if you think giving power over court proceedings to the legislature opens up the process to possible corruption, then you'll want to vote against Issue 1. And that's it! Issue 1 is by far the most complex issue on the ballot, so next time I'll be combining some or all of the remaining issues into a single video. So if you want to see that, make sure to subscribe, and if you want to help make sure these videos keep coming, please support ArkanSense on Patreon. Patreon is like Netflix or Hulu, but for artists. Each month you pay a specific amount to support a maker continuing to put out content. The exact amount is up to you, and bigger rewards get bigger perks. Check out the link in the description below, and thanks for watching. Welcome to my YouTube end card, which doesn't actually work because I can't add these links in until I get 1,000 subscribers. I don't know, YouTube's weird like that. But make sure to check out the description, and see you next time.